Welcome to the Deep Dive, the show that takes a stack of information and extracts the absolute best, most important parts just for you. Think of it as your personal shortcut to being well-informed, maybe with a few surprising insights along the way. It's our mission to guide you through complex topics, helping you connect the dots and gain those crucial insights quickly and efficiently.
And today we are tackling a really significant and, well, often misunderstood area of law. We're embarking on a deep dive into Islamic penal law.
Absolutely. Before we jump in, though, we really want to give credit where it's due. This deep dive is based on materials made available to students by the University of London, and we are incredibly grateful for them providing such valuable resources for educational purposes. This particular deep dive is brought to you by Sinorbit Academy, Sri Lanka.
That's right.
And to all of you students out there, perhaps preparing for your exams right now, we wish you the very best of luck. We really hope this deep dive helps you feel ready.
Yeah, definitely. Our focus today is squarely on helping you grasp the key concepts, remember those important case names and facts, and, feel prepared to tackle questions on this fascinating topic.
Okay.
So let's get started.
Okay, let's unpack this. We're looking at Islamic criminal law, specifically what's called Islamic penal law. Now, if you've explored Islamic law before, you might have encountered UoL.
Right, the principles.
Exactly, the principles of Islamic jurisprudence, the methodology, how they derive the law. But today, we're stepping into UoL.
Which is the substantive law itself.
Yes, the body of specific rules and regulations that come from those principles. So things like contracts, family law, and critically for us today, criminal law. That's our focus.
And it's really important to understand the historical backdrop here. Islamic criminal law, particularly when you look at things like homicide, bodily injury, even rape, well, it didn't just appear out of thin air. It was profoundly shaped by pre-Islamic tribal law, the customs that existed in the Arabian Peninsula before Islam. So you should think of Islamic law's approach in these areas less as a complete, wiping the slate clean.
Right, not a total replacement.
Not a total replacement, more as a significant reform effort. It was attempting to build upon and crucially improve upon those existing tribal customs, trying to bring structure, fairness, where before you often had blood feuds and, frankly, arbitrary revenge.
That historical context is vital, isn't it? For understanding where some of the unique features come from. And it leads us straight to a fundamental difference from systems many of us are more familiar with, like, say, Western criminal law.
Definitely.
Traditionally, Islamic law viewed many criminal offenses primarily as private matters.
This is key.
This is really key, isn't it? The individual victim or their family held significant agency, significant power in these cases, which is quite unlike Western law, where usually the state is the main player responsible for prosecution and punishment.
Although, it's worth pointing out, even in English law, the victim's role is getting more recognized. You see things like compensation orders from courts becoming more common.
True, there's a bit of a shift there, too.
Indeed. However, the modern landscape, well, it's quite different today. The majority of Muslim-majority countries primarily operate under modern penal codes. Many of these are heavily influenced by, continental European or English common law traditions.
So they've moved away from the traditional forms.
Largely, yes. These modern codes have mostly moved away from applying traditional Islamic penal law, as we're going to describe it. And this is where politics and social dynamics really come into play. The rise of political Islam in recent decades has led to a significant reintroduction and application of aspects of traditional Islamic criminal law in certain states.
Okay, where are we seeing this most clearly?
Well, notably in the Islamic Republic of Iran, especially after the revolution when they replaced the older codes, it's very prominent in Pakistan, where General Zia-ul-Haq's Islamization program in 1979 brought in the Hudud ordinances. That was a major shift.
Right, 1979, the Hudud ordinances.
Exactly. You also see it applied in the Muslim-majority states in northern Nigeria. And of course, it's comprehensively applied across pretty much all areas of law in Saudi Arabia.
And Brunei.
And Brunei Darussalam, yes. They notably promulgated a new Sharia penal code back in 2013, specifically incorporating these traditional penalties.
Now, as we dive into this, it's impossible not to acknowledge that some aspects here, particularly around sexual offenses, corporal punishment, they're controversial.
Extremely controversial. They're points of intense debate, both within Muslim communities themselves, debates about interpretation, application, and internationally, especially concerning human rights standards.
So our mission in this deep dive today is to explore classical Islamic criminal law, in its traditional form, and then examine how it's been applied, sometimes adapted, or even limited in some of these modern states we've mentioned. We'll be focusing particularly today on the Islamic Republic of Pakistan.
Right. Our goal is really to help you, the listener, understand the principal features of this legal system. To be able to distinguish between the different types of offenses, that's crucial. To grasp the often very strict evidential requirements that classical law demanded.
Yeah, those evidence rules are key.
They really are. And then to see how these concepts actually play out in specific countries like Pakistan and Brunei.
Okay, so get ready. We're about to lay the essential foundation now by looking at the core categories of offenses. Understanding these categories is absolutely crucial, isn't it?
It really is. Islamic law provides a primary way of categorizing criminal offenses, and it's based on the source of the prescribed punishment. Is it fixed by scripture, or is it left to the discretion of the judge? This gives us the fundamental distinctions: had, tazir, and qisas.
Had, tazir, qisas. Okay, remember those three. Let's start with had. What exactly defines a had offense?
Okay, so had offenses, H-A-D-D. These are offenses for which the punishment is fixed and determined directly by the primary Islamic sources. That means the Quran or the Sunnah, which are the traditions, the practices, the sayings of the Prophet Muhammad, peace be upon him. The term had itself, it actually means limit or boundary.
Ah, okay. Limits set by God.
Exactly. These punishments are seen as the limits set by God, defining serious transgressions against divine law.
And you mentioned these are considered offenses against the right of God. What does that mean in, practical legal terms?
Well, this concept of an offense being against the right of God is really significant. It means that, kind of like the concept of a serious crime in English criminal law, once the court is seized of a had matter, and assuming the very strict evidential requirements are met, the case cannot simply be dropped or settled privately.
So the victim can't just say, okay, I forgive them, let's drop it.
Not for a head offense, no. The aggrieved party, the victim or their family, they can't withdraw the complaint or reach some kind of out-of-court settlement with the accused. The state, acting essentially as the enforcer of God's law, takes over the prosecution to apply that fixed, mandated punishment.
Okay, so had means fixed, mandatory once proven to that high standard, and it's treated as a public right, enforced by the state because it's against the right of God. Got it. What about tazir then? How does that differ?
Tazir offenses are quite different when it comes to punishment. For these offenses, the punishment is not fixed by the Quran or Sunnah. Instead, the determination of the penalty is left to the discretion of the judge.
Ah, judicial discretion.
Exactly.
Yeah.
The judge considers the specifics of the case, the circumstances, maybe the offender's character, general principles of Islamic law, and then decides on an appropriate punishment.
So much more flexibility there.
Much more, yes. Tazir is often applied in several situations. Maybe for offenses where no specific had or qisas punishment is laid out in the sources, or it can be applied for acts that might be related to had offenses but don't meet those incredibly high evidential requirements needed for the had penalty itself.
Like attempted theft, maybe?
Like attempted theft, or perhaps certain sexual acts that fall short of actual intercourse. It can also be used for more general moral lapses or minor transgressions. Now, a critical rule here, and something really important to remember for exams, is that a tazir punishment for an act that's related to a had offense may never exceed the corresponding had punishment.
So it can't be harsher than the fixed penalty.
Exactly. If there's no related had offense, then the judge's discretion is guided by general principles like proportionality, deterrence, and rehabilitation. But it can't exceed the had limit where one exists for a similar act. Remember that constraint.
Got it. Fixed divine punishment, had versus judicial discretion, tazir, with that upper limit. Now let's circle back to the third category, qisas.
Right, qisas, Q-I-S-A-S. These offenses relate specifically to homicide, so killing, and also bodily injuries. Importantly, these are primarily regarded as offenses against the right of an individual, not the right of God.
So back to that idea of it being more like a private matter, with the victim having agency.
Precisely. This is where the victim, or their heirs, have really significant control over the outcome. It's more analogous, perhaps, to a tort in English law than a strict crime where the state dictates absolutely everything. Once guilt is established through the proper judicial process,
Yes.
the aggrieved party, that's the victim themselves if they survive the injury, or in homicide cases, the victim's designated heirs, they have the ultimate decision on what happens next.
And what are the options available to the victim or their heirs in a qisas case? What can they choose?
Typically, they have three main options, and this is a defining feature of the Kisas system. You really need to remember these three. First, they can insist on retaliation, which is also called Kisas. This means demanding the infliction of a similar injury on the perpetrator.
Like an eye for an eye.
Exactly, the principle of an eye for an eye, a life for a life. If someone deliberately killed their relative, they can demand the killer's execution. If someone deliberately blinded someone, they could demand the perpetrator be blinded in return. That's retaliation.
Okay, what's the second option?
Second, they can choose to waive their right to retaliation and instead accept compensation. This monetary compensation is called diya, D-I-Y-A-H. It's often referred to as blood money in homicide cases, or simply compensation for injury.
So they can take money instead of demanding physical retaliation.
Correct. And the third option, they can choose remission. This means completely pardoning the offender. They waive both the right to retaliation and the right to diya, just complete forgiveness.
Wow. Retaliation, compensation, or forgiveness. That's remarkable power given to the individual or the family over the fate of the offender. That breakdown had, fixed, right of God, tazir, discretionary, judge decides, and kisas, homicide injury, right of individual victim control, feels absolutely fundamental to understanding Islamic penal law.
It absolutely is, and understanding these distinctions had, tazir, kisas, is essential as we go forward. Now let's dive deeper into the specifics, starting with those serious had offenses.
Right, and just to quickly recap for everyone listening, these had punishments, they're fixed by Scripture, they cannot be waived or settled privately by individuals if those extremely stringent evidential requirements are met and guilt is established by the court.
Exactly. So let's start with one of the most significant classical had offenses, apostasy, known in Arabic as ridda.
Okay, Rita. What constitutes apostasy in this specific legal context?
Classically, it's defined as the voluntary renunciation or abandonment of Islam by someone who was previously a Muslim.
And the punishment.
The classical punishment prescribed for ridda is death. However, there's a crucial detail here, often mentioned by classical jurists, that you should remember. This punishment is typically only supposed to be carried out after the accused has been given a period of time, often specified as 3 days to repent and return to Islam. They are formally invited to recant their apostasy.
So a chance to repent first. Is this punishment still applied in modern states?
Yes, it is legally prescribed as a capital offense in some modern Muslim-majority states. We see it on the books in places like Saudi Arabia, Yemen, and the Islamic Republic of Iran, though the specifics of its application can vary.
Now, how does this connect to Pakistan, which is our focus country today? Is apostasy a crime there?
This is a really key connection, especially for your understanding of the Pakistani context, so make sure you note this down. Apostasy itself, the act of leaving Islam, is not explicitly listed as a specific criminal offense in either the Pakistan Penal Code, the PPC, or the Code of Criminal Procedure.
Oh, okay, so it's not directly criminalized.
Not under the name apostasy. However, and this is the crucial link, Pakistan's law does have Article 295C of the PPC. This article deals with blasphemy against the Holy Prophet Muhammad, peace be upon him.
Right, the blasphemy law.
Yes, and blaspheming the Prophet is widely considered the most severe form of blasphemy. Under interpretations derived from classical Islamic law, this act is often seen as amounting to apostasy. Therefore, while apostasy isn't the specific crime listed in the code, an individual deemed an apostate in Pakistan could very likely face prosecution under Article 295C for blasphemy.
And face the same penalty?
Potentially, yes. The penalty for blasphemy under 295C is severe, death or life imprisonment. So it's an indirect but very real legal consequence stemming from the link drawn between apostasy and blasphemy against the Prophet in the Pakistani legal context. Remember that link. Apostasy isn't a crime itself, but it's often handled via the blasphemy law, Article 295C.
That's a critical distinction and connection to understand in Pakistan's legal framework. The consequences addressed through the blasphemy law.
Precisely. Okay, moving on to the second most serious classical had offense. Sexual relations outside marriage, known generally as zina, Z-I-N-A.
And what exactly does zina encompass? Does it cover different scenarios?
Yes. Zina classically refers to unlawful sexual intercourse. It covers both adultery, where at least one of the parties involved is married to someone else, and fornication, where neither party is married. The absolute core requirement is actual sexual penetration.
So if it's, say, intimate contact but not actual intercourse, does that still count as a had offense?
No, and this is another important distinction to remember. Other sexual acts or intimate contact that do not involve actual sexual intercourse do not constitute the had offense of zina. These lesser acts would typically be punishable, but at the judge's discretion as tazir offenses based on their perceived severity.
Okay. And the prescribed had punishments for proven zina.
The punishment depends on the marital history of the individual convicted. For a person who has ever been married, this includes someone currently married, widowed, or divorced. The punishment for zina, if proven to the incredibly high had standard, is death by stoning.
Death by stoning. And for someone never married.
For a person who has never been married, the punishment is 100 lashes.
Death by stoning or 100 lashes. Those are obviously extremely severe. But you keep mentioning that the evidence required for had zina is famously difficult to obtain.
Absolutely correct. This is a point you must remember, as it highlights the theoretical strictness of classical had application. To prove the had offense of zina and impose that fixed punishment, the evidential requirements are extraordinarily high. You need to know these.
Okay, what are they?
The primary method of proof requires the testimony of 4 eyewitnesses. 4.
4 eyewitnesses?
Yes, and these witnesses must meet specific criteria. They must be adult, sane, male Muslims. Furthermore, they must possess the highest degree of moral probity, often described using the term ad, meaning they are known to be upright, righteous, consistently abstaining from major sins.
Okay, 4 adult, sane, morally upright Muslim men.
And here's the most difficult part. They must testify to witnessing the actual act of intercourse itself. They must literally have seen the penetration occur.
Wow. 4 such men witnessing such a private act. That sounds, well, virtually impossible in reality.
Wow. It is designed, many argue, to be almost impossible to meet in practice. The intent behind such a high standard is often debated. Was it to prevent the had punishment from being applied except in the most undeniable public circumstances, pushing most cases towards lesser tazir punishments? Or was it simply the standard mandated by Scripture, regardless of practical difficulty? Either way, it sets an incredibly high bar. 4 eyewitnesses to the act. Remember that.
Okay, 4 eyewitnesses. Is there any other way to prove had zina?
Yes, there is an alternative.
Yeah.
The confession of the accused. However, even a confession comes with a very strict condition attached. The accused must maintain their confession throughout the entire process, right up until the punishment is actually carried out.
They can't change their mind.
If they retract their confession at any point before or even during the execution of the punishment, the had punishment is typically suspended or canceled. So it has to be a maintained confession.
So the 2 routes are 4 impeccably moral male eyewitnesses to the physical act of penetration or a confession that is never withdrawn. What about other kinds of evidence people might think of, like, say, pregnancy outside of marriage? Does that count for had?
This is another crucial detail to remember for your exams. Under traditional classical Islamic law, pregnancy outside marriage does not constitute sufficient proof of the had offense of zina.
Really? Even though it proves intercourse occurred?
While it certainly would be strong evidence that intercourse occurred, it lacks the specific, direct eyewitness testimony required by the rules for imposing the had penalty. Pregnancy might be used as evidence leading to a conviction for a lesser tazir punishment based on the judge's discretion, but it cannot, on its own, lead to the fixed had punishment of stoning or 100 lashes. Remember that. Pregnancy is not sufficient proof for had zina.
This exceptionally high standard of proof really does raise questions when we look at historical or modern instances where executions for zina have reportedly occurred. You mentioned executions in the early years of the Islamic Republic of Iran, for instance. If the Sharia standard is so incredibly high, how are those convictions actually obtained?
That is precisely the question that the source material raises, and it's a point of critical analysis. Given the near impossibility of meeting the classical Sharia proof standard, the 4 eyewitnesses to the act, or the requirement for a confession maintained without coercion, it remains unclear exactly how convictions leading to the had punishment of execution were secured in those instances, like in early post-revolution Iran.
So it suggests a potential gap.
It certainly suggests potential departures from, or perhaps different interpretations of, the classical evidentiary principles in actual practice. It highlights the critical difference that can exist between theoretical legal principles written in texts and their real-world application by courts or authorities.
A stark illustration of that potential gap. Okay, let's move to the third major classical had offense, theft, known as sarika, S-A-R-I-Q-A-H.
Right, sarika. Classically, this is defined as taking and carrying away, without any right, a thing of value from what's considered a protected place or custody.
Are there limitations on what kind of thing can be stolen for it to qualify as had sarika?
Yes, there are specific conditions here too. The object stolen must have recognized value in Islamic law. Things considered haram, forbidden, or inherently without legitimate value, like pigs, pork, or wine, cannot be the object of had sarika.
So stealing wine wouldn't trigger the had penalty.
Not the had penalty for theft, no. The object must also possess intrinsic monetary worth, and it has to be above a certain minimum threshold, often referred to as the nisab. Also, simply finding something that was lost doesn't constitute sarika. It has to be taken from a place of protection or custody.
Okay. What about the evidence required for had sarika? Is it as strict as for zina?
Yeah, it is also strict, but slightly less demanding than for zina. For had sarika, the requirement is the testimony of 2 eyewitnesses.
Who, not four?
2 eyewitnesses. Like the witnesses for zina, they generally must be adult, sane, Muslim males possessing a high degree of moral probity. And, crucially, they must testify to having witnessed the actual act of theft occurring.
And what about circumstantial evidence? Say, if someone is caught with the stolen goods, is that enough for the had punishment?
Absolutely not for the had punishment. This is another critical rule you must remember. Circumstantial evidence, no matter how strong it might seem, like the accused being found in possession of stolen goods shortly after the theft, or having their footprints at the scene, is never sufficient under classical Islamic law to secure a conviction leading to the had punishment of amputation.
Never sufficient for had.
Never. Circumstantial evidence, or maybe a confession that's later retracted, or perhaps testimony that doesn't meet the full witness standard, these might lead to a lesser tazir punishment, like imprisonment or lashing at the judge's discretion. But it will not result in the fixed had penalty of amputation. Remember, no circumstantial evidence for had conviction.
Okay, that's clear. And the prescribed had punishments for sarika, if proven by the 2 witnesses or a confession.
The classical punishment for had sarika follows a progressive amputation scheme based on repeat offenses. For a first proven offense, the punishment is the amputation of the right hand at the wrist.
Right hand first.
Right hand first. If the offender is convicted of had sarika again, the punishment is the amputation of the left foot. A subsequent conviction could result in the amputation of the other hand, the left one, and finally the remaining foot, the right one, for further offenses. It's a progressive sequence.
So amputation for theft, stoning or lashing for unlawful sexual relations, and death for apostasy, provided those extremely high standards of proof are met. These are the major classical had offenses we've discussed. Are there any others typically included in the list?
Yes, there are a few more commonly listed classical had offenses that you should be aware of. Fourth on the list is usually Qadhf, F-E-D-H-F. This means falsely accusing a chaste person, typically. The law focuses on accusing a chaste woman of committing zina.
Falsely accusing someone of zina. Why is that considered a had offense itself, with a fixed punishment?
Well, think about it. Because the accusation of zina itself is so incredibly serious and the potential had punishments associated with it, stoning or lashing, are so severe, making a false accusation that could subject someone to that kind of jeopardy is considered a very grave transgression. It's seen as undermining the integrity of the legal system, destroying an individual's reputation in a profound way, and thus an offense against the right of God.
Okay, so it's about protecting people from false accusations of such a serious crime. What's the punishment for Qadhf?
The prescribed had punishment for quat, if proven, is 80 lashes.
80 lashes for false accusation of zina.
Yeah.
Got it. What's next on the list?
Drinking intoxicants is also a classical had offense. Classically, this referred primarily to drinking wine, fermented grape juice. Some modern interpretations and state laws, for instance in Saudi Arabia, have extended this to include the taking of other intoxicants, sometimes even hallucinatory drugs.
And the punishment for drinking?
The prescribed had punishment for this offense is typically 80 lashes.
80 lashes again, same as for quait.
Hmm.
Is the nature of those lashes the same as, say, the lashes for zina for an unmarried person?
This is a very specific and important detail highlighted in the source material, and definitely something to remember. While the number of lashes might be the same, 80 for quad, 80 for drinking, 100 for fornication, the nature and the purpose of the lashes for the had offense of drinking intoxicants is traditionally understood quite differently than lashes for zina or quite.
Wow.
For drinking, the lashes are traditionally intended primarily to shame the person publicly, not necessarily to inflict significant physical harm or pain. Classical texts actually provide recommendations for a lighter application. things like holding the whip or lash lightly between the first and second fingers, or the Maliki school's recommendation of holding an object, like a book, under the armpit while administering the lashes. This prevents the arm from being raised too high and limits the force of the blow.
Interesting. So it's more about public disgrace than physical punishment.
That's the traditional understanding for the had of drinking. This contrasts sharply with lashes that might be applied for zina or khalaf or other offenses under tazir, remembering that tazir punishments, including lashes, cannot exceed the had limit, so lashes are relevant there too. In those cases, the intention is typically understood to be inflicting pain and harm as a deterrent and punishment. So definitely remember the distinction in the nature and intent of the lashes depending on the specific offense, shame for drinking, harm punishment for others.
That's a fascinating nuance, sham versus harm, even when the number of lashes might be similar. What's the final common head offense usually listed?
The final one is haraba, Hirabah. This is often translated simply as highway robbery. However, the term classically covers a broader range of offenses, often committed by stealth or force involving violence, intimidation, or brigandage against travelers, communities, or disrupting public order and safety.
So broader than just robbery on a road.
Yes, it can include things like armed robbery, banditry, spreading terror. The classical punishments for haraba are severe and are explicitly prescribed in the Quran in Surah 5, verse 33. These punishments can include crucifixion, execution, amputation of hands and feet from opposite sides, or exile from the land, depending on the nature and severity of the acts committed, for instance, whether they caused death, injury, or merely took property through force or stealth.
Okay, so to recap the main classical had offenses, we have apostasy, ridda, unlawful sexual intercourse, zina, theft, sarika, false accusation of zina, drinking intoxicants, shurb al-khams, and highway robbery brigandage, hirba, each with fixed, severe punishments, but crucially contingent on meeting those notoriously high standards of proof.
Correct. And it's really important as you study this to note how modern states have actually dealt with these. For example, look at Malaysia. The application of these traditional had punishments is significantly limited there by federal statute. The Muslim Courts Criminal Jurisdiction Act of 1965 basically puts a cap on the punishments that the Syariah courts in Malaysia can impose.
What's the cap?
The maximums are set at 3 years imprisonment, a fine of 5,000 Malaysian ringgit, or a maximum of 6 lashes.
6 lashes maximum.
6 lashes maximum from the Syariah courts under that act. This legal limitation means that the traditional head punishments we just discussed, like amputation for theft, stoning for adultery, crucifixion for haraba, or the death penalty simply cannot be applied by these courts in Malaysia.
So it's a legislative decision to limit the severity.
Exactly. It illustrates a conscious legislative choice in a modern Muslim-majority state to retain elements of Sharia criminal law, but to specifically limit the severity of the penalties, particularly regarding the classical head punishments. It shows that even where Islamic law is applied, its form can be significantly modified by modern legislation.
That's a very different approach to application compared to countries that might seek to implement the classical punishments more fully, like Saudi Arabia or as legislated in Brunei. It really highlights the diversity of legal systems and approaches even within Muslim-majority states today.
It certainly does. Now, shall we shift our focus to the third category of offenses we identified earlier? That's qisas, dealing with homicide and bodily injuries. And remember, the key here is that these are primarily considered offenses against the right of an individual.
Right. And you mentioned earlier that this area of law, qisas, represents a significant reform of pre-Islamic tribal custom. Can you maybe elaborate a bit more on what the situation was like before Islam regarding killing and wounding?
Sure. Before Islam, the custom for dealing with killing and wounding in the Arabian Peninsula was largely based on tribal blood feuds. It was pretty brutal. If someone from Tribe A killed or injured someone from Tribe B, the reaction was often not just targeting the individual perpetrator.
It was collective.
Very much so. The injured tribe's sense of honor, their collective identity, demanded retaliation. And this retaliation often targeted several members of the aggressor's tribe, not just the person who committed the act. This could, and often did, spiral into prolonged, incredibly violent and destructive intertribal conflicts, these infamous blood feuds, which could last for years, claim many lives, and cause immense social instability.
That sounds like a recipe for constant warfare and chaos.
Yeah.
How did Islamic law reform this system? What were the key changes?
Islamic law introduced 3 major crucial reforms to this system that were a radical improvement and are really important for you to remember. Three key reforms for Kisas. First, it firmly established the principle of individual liability.
Only the perpetrator is responsible.
Exactly. Only the guilty party, the actual person who committed the killing or wounding, was held liable for the crime and subject to punishment. The entire tribe or clan was no longer held collectively responsible or targeted for retaliation. This immediately limited the potential scope of conflict.
Okay, individual liability. What was the second reform?
Second, it introduced an intent requirement. Punishment, especially retaliation, was generally only imposed if the killing or wounding was committed deliberately and wrongfully. Unintentional or accidental harm, while it might still require compensation, dia, was treated differently than deliberate, malicious acts. This introduced a crucial distinction between different degrees of culpability.
Intent matters.
Yeah.
And the third, reform.
Third, it mandated a judicial process. The facts of the case and the guilt of the accused person had to be established before a ruling authority or a judge. This introduced a formal legal structure and impartial determination of facts, replacing the immediate, often arbitrary, and passion-fueled tribal retaliation that existed before.
Individual liability, intent requirement, judicial process. Those seem like fundamental steps towards creating a more just and ordered society compared to endless blood feuds. But you also said earlier that the principle of personal vengeance, or perhaps better termed victim control, was somehow preserved. How does that fit in?
Yes, and this is the really unique characteristic of the Kisa system that distinguishes it quite sharply from most modern criminal law systems. Despite introducing these vital reforms, individual liability, intent, judicial process, the underlying principle that the harm was primarily done against the individual or their family was preserved.
So the victim still has the final say.
In a crucial way, yes. It means that the victim or their heirs, in homicide cases, not the ruler or the judge, have the ultimate decision on the punishment or the outcome once guilt has been established by the court. The court does its job. It determines the facts, establishes guilt according to strict evidential rules, which are different from Had, by the way. Kisas typically requires confession or testimony of two witnesses. But the focus is more on the act itself rather than the witness's moral probity in the same intense way as Had. But the consequence of that guilty verdict, that rests with the aggrieved party.
Okay, so the court finds guilt, but the victim or the victim's family decides the ultimate outcome. Let's just reiterate those three options they have again, because they're so central.
Absolutely. Worth repeating for clarity. The three main options for the victim or the heirs in Kisas cases, once guilt is established by the court, are
Retaliation,
yeah,
he says, demanding the infliction of a similar injury or death on the perpetrator. Life for life, eye for eye.
compensation, dia, waiving the right to retaliation and agreeing to accept monetary compensation from the culprit instead. Remember the term dia.
Remission, granting a complete pardon to the offender, waiving both the right to retaliation, kosias, and the right to compensation, dia, forgiveness.
Retaliation, compensation, or remission. Those three options decided by the victim or heirs. This system gives immense power and responsibility to the victim's family. How is the amount of dia, the compensation, calculated? Is it fixed?
Dia is a monetary sum, yes. Traditionally, its value depended on several factors, including the nature of the injury. There were often specified amounts for the loss of a limb, an eye, a tooth, etc., and also significantly the status of the victim.
Status of the victim? How so?
Well, for a woman, the dia amount for a deliberate killing or injury was classically fixed at half the rate payable for a man. For a slave, the amount wasn't usually fixed by a standard rate, but was typically determined by the market value of that slave.
And you mentioned earlier that there was differing views among the classical schools of law regarding victims who were slaves or non-Muslims.
Yes, this is a point of significant juristic divergence, different opinions among the schools that you should definitely be aware of. When a free Muslim perpetrator kills a slave, or when the victim of a homicide is a non-Muslim, like a Dhimmi or Muslimin living under Muslim rule, the schools of law differ on whether Kisas, retaliation, i.e. execution of the perpetrator, is permissible at all.
So not all schools allowed a life for a life in those cases.
Correct. Only the Hanafi school of law generally allows for retaliation, Kisas, in cases of deliberate homicide, when the victim is a slave killed by a free Muslim, or when the victim is a non-Muslim. The other major Sunni schools, Maliki, Shafi'i, Hanbali, and many other sects, typically restrict the punishment in such cases to the payment of dia only, not Kisas.
And was the dia amount the same?
Often not. Furthermore, the amount of dia payable for a non-Muslim victim was typically reduced by most schools to a lower level, than that required for a Muslim victim, although again, some Hanafi jurists argued it should be equal in cases of deliberate homicide. So definitely remember this point about the differing views, particularly the Hanafi position generally allowing qisas for killing certain non-Muslim victims, where other schools restricted it to daya, and the variations in the daya amount itself based on the victim's status.
That really illustrates how interpretations could vary significantly even within the classical tradition. Now, to bring these Kisa's principles and maybe some procedural aspects to life, you mentioned you have a real-world case example.
Yes, the McLaughlin and Perry case from Saudi Arabia back in 1996. It's a detailed example that vividly illustrates several aspects of Saudi Arabian criminal law in practice, particularly concerning qisas and also important procedural elements like the validity of confessions. This is a good case to remember.
Okay, the McLaughlin and Perry case, 1996, Saudi Arabia. Remind us of the basic facts.
Sure, this case involved two British nurses working in Saudi Arabia, Lucille McLaughlin and Deborah Kim Perry. They were accused of murdering their Australian colleague Yvonne Guilford. It became a massive international news story at the time.
And procedurally, what was notable about it?
Procedurally, it was quite significant because it was believed to be the first time that foreign accused in such a serious criminal trial in Saudi Arabia were actually represented by Saudi Defense Counsel. The trial itself was also described by observers as being unusually open compared to previous trials of that nature in the kingdom.
And what arguments did their Saudi Defense Counsel make, particularly regarding the confessions the nurses had reportedly made?
Their counsel made really significant submissions regarding the validity of confessions under Sharia law. They argued very strongly against accepting confessions obtained under any form of duress, and importantly, they defined duress broadly, not just physical violence, but also moral or psychological pressure.
Going beyond just physical beatings.
Absolutely. They cited respected Islamic jurists who considered various tactics as constituting duress sufficient to invalidate a confession. This included not just physical force, but also things like making promises, like promising release if they confess, making threats, subjecting suspects to prolonged interrogation, interrogating them late at night when they're exhausted, and even using psychological tricks or deceptions.
Psychological deceptions? What kind of examples did they give?
Examples like the interrogator falsely telling one suspect that their co-accused had already confessed and implicated them, or falsely claiming that compelling forensic evidence, like fingerprints or DNA, had been found linking the suspect to the crime scene, even if it hadn't. The counsel argued that if these tactics, or really any degree of pressure, contribute to the accused's breakdown, leading them to make a false admission simply to end their suffering or confusion, then that confession is considered null and void under established Sharia principles.
And they argued confessions need backup.
Yes, they emphasize the classical juristic view that a confession should ideally be the start of the evidence-gathering process, something that requires corroboration, not the sole conclusive basis for conviction and punishment, especially in serious cases.
That's a very nuanced argument about coercion, extending well beyond just physical force. How did the Kisa's principle, specifically the options for the victim's family, play out in this case?
This is where the Kisa's options became very real. Initially, the victim's brother, Frank Guilford, as the closest male heir, Wali al-Dam, demanded retaliation, Kisa's. If the nurses were found guilty of deliberate homicide, his demand would have meant their execution.
He demanded the death penalty.
Yes. However, there were intensive diplomatic efforts, particularly involving the British government, and even figures like Prince Charles, communicating directly with the victim's family. These efforts were aimed at persuading the victim's brother to exercise his right under Kisa's law to waive retaliation and accept daya, blood money, instead.
So they were trying to get him to choose the second option, compensation.
Exactly. And eventually, he did agree to accept daya. This demonstrates very clearly the practical application of the Kisa's options in a high-profile case, the power held by the victim's family to commute a potential death sentence to a financial settlement. Remember this aspect of the case, the shift from demanding Kisa's to accepting daya due to negotiation and perhaps diplomatic pressure.
And what was the final legal outcome in the Saudi courts? Were they found guilty?
The trial findings were reportedly somewhat complex. Lucille McLaughlin was apparently found guilty as an accessory to murder, while Deborah Kim Perry's guilt for the murder itself was perhaps less conclusively determined in the final judgment. However, the crucial point is that ultimately both nurses were pardoned by the late King Fahd of Saudi Arabia and repatriated back to the UK.
A royal pardon.
Yes. And the fact that a royal pardon was needed strongly implies that there must have been some finding of guilt against both of them, sufficient under Saudi law to trigger the Qisas claim or warrant other serious punishment. Otherwise, a pardon wouldn't have been necessary for their release. So the McLaughlin and Perry case is a key real-world example. Remember it for illustrating the debate around confessions under Sharia, coercion issues, and the practical application of the dia option in a serious Qisas case involving homicide.
A truly significant case for understanding these concepts in practice. It also makes me wonder, given the different juristic views you mentioned earlier, like the Hanafi position on Qisas for non-Muslims versus other schools, when modern states like Saudi Arabia apply these laws today, which specific school of law's interpretation do they tend to follow? Does the state legally codify one school's view, or is there still room for judges to pick and choose between different classical opinions?
That's a really insightful question. Saudi Arabia's legal system is historically and strongly influenced by the Hanbali school of Sunni jurisprudence. That's its foundation. However, it's not just pure classical Hanbali law being applied directly from ancient texts. It's administered through a modern statutory framework established by the state, with royal decrees, regulations, and codified procedures. So while Hanbali principles are foundational, the specific codified laws passed by the state and the discretion granted to judges within that system ultimately determine which specific interpretations, especially on points where the schools historically diverged, like the dia rate for non-Muslims, are actually applied in practice in the courts. It's not always a pure, unadulterated application of one classical school, but rather an interpretation and implementation within a modern state legal structure, which can sometimes lead to further variations or specific state policies overriding certain classical views.
Fascinating. So it's classical principles interacting with and sometimes being shaped by modern state legal structures and political decisions. Okay, so we've covered the core categories, had, tazir, and Qisas, and delved into the specifics with definitions, evidence, rules, and examples like McLaughlin and Perry. Now, let's really turn our attention to the application of Islamic penal law in modern states, with that strong focus you promised on Pakistan.
Yes, Pakistan provides a really crucial and complex case study in the modern implementation and subsequent reform of Islamic penal law. As we mentioned right at the start, Pakistan deliberately reintroduced aspects of traditional Islamic criminal law into its legal system back in 1979. This was part of General Zia-ul-Haq's broader Islamization program.
And this was a big shift.
It was a hugely significant shift, yes. It really distinguished Pakistan from many other Muslim-majority countries, especially former British colonies, that had largely retained modern penal codes based on colonial-era laws, like the Indian Penal Code, which Pakistan inherited. Pakistan, along with Saudi Arabia and some Gulf states, became one of the key countries that specifically codified and actively sought to apply traditional Islamic penal law concepts to certain categories of offenses.
And this reintroduction happened primarily through a specific set of laws, didn't it?
Yes. The legislative vehicle for this reintroduction was primarily a series of ordinances promulgated in 1979, collectively known as the Hudud Ordinances of 1979. For our discussion on penal law, the three most significant ones you need to remember are: 1. The offenses against property, enforcement of Hudud Ordinance. 2. The offense of zina, enforcement of Hudud Ordinance. 3. The offense of Qas, enforcement of Had Ordinance. Remember those three. Property, zina, and Qas Hudud Ordinances, 1979. They form the statutory basis for bringing back traditional penalties.
Okay, Hudud's Ordinances, 1979. Now, you highlighted earlier that for the had punishments prescribed under these ordinances, a very high evidential burden is required, mirroring classical law. Can you give us the specifics again, for example, for had theft under the Pakistani law? What exactly does the ordinance say?
Absolutely. It's good to revisit this to see how the classical rules were codified. Under the offenses against property, enforcement of Hudud Ordinance, 1979, to impose the had punishment for theft, which, remember, is amputation of the right hand for a first offense. The proof requirements are spelled out in detail. It requires one of two things. Either the accused person pleads guilty to the charge before a court of competent jurisdiction. That's one way.
Okay, a formal guilty plea in court.
Or alternatively, it requires the testimony of at least 2 Muslim adult male witnesses. And crucially, these witnesses must be deemed by the court to be truthful persons. The law uses that phrase, who have not previously been convicted of perjury, quasvif, and who are known to have, in the past, abstained from major sins, kabair. So that high moral probity standard is codified.
2 truthful, sin-abstaining Muslim male witnesses.
Yes, and they must be actual eyewitnesses to the occurrence of the theft itself. They must have seen it happen. The law also specifies a procedural point. The statement of the victim of the theft must be recorded first before the statements of these eyewitnesses are taken by the court. So that's the specific, very stringent evidential requirement codified in Pakistan for had theft, guilty plea, or to truthful sin-abstaining Muslim male eyewitnesses to the act. Remember those details.
That level of detail in the statutory requirements is really striking. It shows they were trying to codify the classical rules quite closely there. Now let's focus in on the Zina Ordinance, 1979, particularly its impact before the significant reforms happened in 2006. You mentioned earlier that it caused significant injustice, especially for women. Can you unpack that for us?
Yes, this is an absolutely crucial point to understand and something you really need to remember about the original Xena Ordinance of 1979 because its consequences were incredibly severe and became widely criticized internationally and domestically. The ordinance criminalized any sexual intercourse between a man and a woman who were not validly married to each other under Islamic law.
Any intercourse outside marriage.
Any intercourse. This definition was extremely broad. It effectively lumped together adultery, if one party was married, fornication, if neither was married, and also, critically, rape, all under the umbrella of zina. All these acts were potentially liable to the severe hand, punishment stoning if married, 100 lashes if unmarried if, and it's a huge if, the strict had evidence could be presented. The ordinance also incorporated the kasvaf provision from classical law, meaning someone making a false accusation of zina could themselves face punishment, classically 80 lashes.
Okay, so it covered adultery, fornication, and rape. How did this structure specifically create hardship and injustice for women, particularly those trying to report rape? This seems to be the core issue.
This is exactly where the severe problem arose, and it's vital you grasp this specific mechanism of injustice. Under the 1979 Xena Ordinance, think about what happened when a woman reported being raped. She had to go to the authorities, usually the police, and file a formal complaint, an FIR, First Information Report.
Yeah.
In doing so, she necessarily had to admit that sexual intercourse had taken place that was the basis of the rape claim.
Right, she has to state what happened.
Exactly. The prosecution for rape was then conducted under the Xena Ordinance. Now, if the case went to trial and the accused rapist was acquitted, which was extremely common, almost inevitable in most cases, because it was virtually impossible for the prosecution to meet the had standard of 4 pious male eyewitnesses to the actual act of penetration required for a had conviction for zina.
Which would be needed even if the charge was rape under that ordinance.
Yes, because rape was prosecuted as zina under that law, the had standard technically applied if the had punishment was sought. Since that standard was almost never met, the accused was usually acquitted of the had charge. This meant the allegation of rape was legally deemed unproven due to insufficient evidence to the had standard. Now, here's the terrifying legal reversal. The woman, having admitted in her initial complaint that intercourse took place, now faced a horrific situation.
Because her claim of non-consent wasn't proven.
Exactly. Because she had admitted intercourse, and her claim that it was non-consensual rape was deemed unproven according to the strict evidential rules of the Xena Ordinance. She can now be charged herself with the offense of zina, either adultery, if she happened to be married to someone else, or fornication, if she was unmarried.
So the victim becomes the accused.
Precisely. This perverse outcome effectively meant that the act of reporting rape carried the severe risk that the female complainant could end up being charged with a serious crime herself, potentially facing the draconian had punishments of stoning or lashing. It made it incredibly dangerous, legally perilous, and often practically suicidal for women to even attempt to seek justice for rape under that original 1979 law. You absolutely must remember this specific mechanism of injustice created by the 1979 Xena Ordinance, how reporting rape could lead to the victim being prosecuted for zina due to the high evidence standard for rape and her admission of intercourse.
That is a truly horrific legal trap, penalizing the victim for reporting the crime. It's essential to understand that specific consequence.
It was a major source of criticism, leading to campaigns by women's rights groups, human rights organizations, and legal scholars for reform over many years. Recognizing these severe injustices and the profound hardship caused, particularly to female victims of sexual violence, Pakistan finally enacted key reform legislation in 2006. This was the Protection of Women Criminal Law Amendment Act, 2006.
The Protection of Women Act, 2006.
Yes. Remember this act name and its primary purpose. It was specifically designed to address and rectify the problems and injustices created by the 1979 Hudud ordinances, especially the Xena Ordinance and its impact on women.
Okay, so how did the 2006 Act change things? What were the main reforms it introduced?
The act brought about several fundamental and crucial changes. You need to know these key reforms. First, It took a number of offenses that had been previously bundled under the Hudud ordinances and moved them back into the main Pakistan Penal Code, PPC, of 1860, which, remember, is primarily based on common law principles and has different evidentiary rules.
Which offenses were moved back?
Examples include offenses like kidnapping or abducting someone to compel them into marriage or illicit sex, kidnapping a male minor for unnatural lust, selling a minor for prostitution. These are now dealt with under the General Criminal Code, the PPC, not the Hudud ordinances.
And the crucial offense of rape, was that moved too?
Yes. Critically, rape was also moved back to the Pakistan Penal Code. The 2006 Act provided a new, redefined offense of rape under the PPC. This new definition explicitly included marital rape as a possibility in certain circumstances, and also clearly criminalized sexual intercourse with a female under the age of 16, regardless of whether she appeared to consent.
And the punishment under the PPC?
The punishment range for rape under the amended PPC is severe: death or imprisonment for a term not less than 10 years and up to 25 years, plus a fine. So rape is now firmly back under the general criminal law with its own definition and penalties.
Okay, so rape is out of the Zina Ordinance. What happened to the offense of zina itself? Was that abolished?
No, not entirely. The Act redefined and effectively split the concept of zina. The term adultery is now specifically defined as sexual intercourse between a man and woman where one or both are married but not to each other. Fornication is defined as sexual intercourse between a man and woman where neither party is married.
So adultery and fornication are now distinct.
Yes, and crucially, fornication was created as a new, separate offense and inserted directly into the Pakistan Penal Code, PPC, Section 496B. It was not kept under the Zina Ordinance. And importantly, this new PPC offense of fornication carries significantly lesser penalties than the traditional had punishments.
What are the penalties for fornication under the PPC?
Imprisonment for up to 5 years and a fine not exceeding 10,000 Pakistani rupees. Much less severe than stoning or 100 lashes.
Is there any safeguard against people making false accusations of fornication now that it's a PPC offense?
Yes, the legislators recognize the potential for misuse here as well. The 2006 Act included a specific safeguard. It created a new corresponding offense of false accusation of fornication within the PPC, Section 496C, punishable by the same range: imprisonment for up to 5 years and a fine up to 10,000 rupees.
And how does that work procedurally?
Crucially, the Act introduced a specific procedural mechanism to handle this risk directly within the trial process. If a prosecution for the PPC offense of fornication results in an acquittal, the accused is found not guilty, the trial judge can, in the very same proceedings where the acquittal just occurred, immediately proceed to try and sentence the original complainant for making a false accusation, if the judge is satisfied that the complainant knowingly brought a false charge.
So the complainant could be convicted right there and then?
Potentially, yes. It aims to deter false claims, but it also clearly places the complainant at potential risk within the same court appearance if their case fails and is deemed false.
Okay, so fornication is now a lesser offense under the PPC with a safeguard against false accusations. What about adultery? Where does that fit now?
This is another key outcome of the 2006 reforms, and another point you must remember. Adultery is the only offense related to illicit intercourse that was kept under the original offense of zina, enforcement of Hudud Ordinance, 1979. It wasn't moved to the PPC like fornication and rape were.
Only adultery remains under the Zina Ordinance.
Yes. Making a false accusation of adultery was also kept as an offense, primarily dealt with under the separate Quasaf Ordinance, though the punishment was aligned with the new PPC penalties for false accusation of fornication. Now, importantly, the 2006 Act also added a new, specific definition of confessions directly into the Zina Ordinance itself.
Why was that needed?
This was specifically designed to prevent that previous injustice to stop a woman's statement admitting intercourse, made as part of a rape allegation, from being automatically twisted and treated as a deemed confession to zina if her rape claim was subsequently unproven due to lack of had evidence. This new definition provides clearer criteria for what constitutes a valid confession for the purposes of the Zina Ordinance, directly tackling that terrible procedural trap from the 1979 law. Remember this specific reform regarding the definition of confession.
That sounds like a direct and vital response to the problem created by the original law. Were there any other major changes made by the 2006 Act that addressed specific hardships?
Yes. Another significant change was the deletion of the definition of what constituted a valid marriage from the Zina Ordinance. This might sound technical, but it was important. The previous definition had caused significant hardship, particularly for women who had obtained divorces, talaq, that were perfectly valid under religious law, but where the husband had failed perhaps deliberately, to give the formal notice of that divorce required by Section 7 of the Muslim Family Laws Ordinance 1961.
How did that cause a problem?
Believing themselves properly divorced according to religious rites, these women would sometimes remarry. The first husband could then exploit the technicality of the missing formal notice under the 1961 law to claim she was still legally married to him on paper, and then maliciously bring a zina charge against her and her new husband for adultery based on her remarriage. Deleting that specific definition of valid marriage from the zina ordinance helped to resolve that particular source of legal manipulation and injustice.
Okay, that makes sense. Now, you mentioned adultery remains under the Zina ordinance. What about the punishment options? Is tazir still available there?
No, and this is perhaps one of the most profound consequences of the 2006 Act, and something you absolutely must understand. The 2006 Act removed the tazir option from the zina ordinance entirely.
Tazir is gone from the Zina ordinance. What does that mean in practice?
It means that now, under the amended zina ordinance, the offense of adultery can only be proved in one of two ways. Either by meeting the extremely strict ad evidential standard, that is, the testimony of 4 truthful adult male Muslim eyewitnesses who personally witnessed the actual act of penetration, or by the accused person making a valid confession before the court.
Only had evidence or confession for adultery now.
Yes. And because the discretionary tazir punishment option has been completely removed from the zina ordinance itself, the only punishment available under that ordinance for adultery, if it is proven by either the had standard or a valid confession, is death by stoning.
The only punishment is death by stoning. No lesser option.
No lesser punishment remains within the zina ordinance itself for the specific crime of adultery defined within it. This is a key implication of the 2006 reform. Removing tazir from the zina ordinance made the stakes incredibly high acquittal, or conviction leading only to the had penalty of stoning. Remember this consequence.
That's an incredibly high-stakes outcome. Meet the had standard or confess. And the only statutory punishment for adultery under that specific ordinance is death by stoning because tazir was removed.
Exactly. The 2006 Act also significantly amended the procedure for prosecuting these sexual offenses, aiming to filter cases more rigorously. For adultery, which remains under the zina ordinance, complaints must now be filed directly in court. They don't go to the police for investigation first.
Straight to the judge.
Straight to the court. The judge must then personally examine the complainant under oath. And most importantly, the judge must also examine at least 4 truthful adult male eyewitnesses, also under oath, who must testify directly to witnessing the act of penetration that is the strict Sharia evidence required for had. Only after the judge has done this and is satisfied there's a prima facie case meeting this high standard can the judge issue a summons for the accused person to appear.
Wow, so the 4 eyewitnesses have to testify before the accused is even summoned.
Yes, it's a very high procedural barrier intended to filter out cases that clearly cannot meet the had standard right at the beginning, before formal proceedings even began against the accused person. It's a significant procedural safeguard introduced in 2006.
That sounds like a much more rigorous initial filter than before. What about the cause law, the false accusation law under these amended procedures? What happens if the adultery prosecution fails after going through this?
The cause of enforcement of the had ordinance, 1979, was also amended by the 2006 Act, and this is another critical consequence for complainants to remember. If an adultery prosecution, initiated under this strict new procedure, ultimately fails in court, for example, the witnesses are not deemed credible or the evidence doesn't hold up, the punishment for cause of, false accusation, against the original complainant is now virtually automatic.
Automatic punishment for cause.
Almost. If the judge who heard the failed adultery case is satisfied that the complainant committed the offense of causative by making a false accusation, that same judge will sentence the complainant to the had punishment for causative, which is 80 lashes without requiring separate proof or a separate trial for the causative offense. It happens within the same proceedings.
That's incredibly severe. Fail in your adultery claim and you automatically get 80 lashes.
It's a very severe and near-automatic consequence intended to deter false accusations of adultery, given the gravity of the charge. Furthermore, and this is another key point, a person convicted of quas under this ordinance has their testimony rendered legally inadmissible in any future court proceedings in Pakistan.
Their testimony is invalid in court forever.
Yes, it has profound implications for their ability to act as a witness, to bring claims, or even defend themselves effectively in any future legal matter. So remember this, the near automatic conviction and punishment, 180 lashes for cause if an adultery case fails, and the permanent consequence of rendering the convicted person's testimony inadmissible.
Those are very serious legal consequences indeed, extending far beyond just the physical punishment. And the procedure for fornication complaints, which are now under the PPC, is it similar?
It follows a similar procedural model, requiring pre-summoning examination, but with a lower witness requirement, reflecting the fact that it's now a PPC offense, not a HAD offense. For the PPC offense of fornication, the judge must examine the complainant and at least 2 eyewitnesses in court before a summons is issued for the accused. Again, it's a procedural filter requiring a certain standard of direct evidence up front, but 2 witnesses instead of 4.
Okay, that clarifies the procedural changes. Moving slightly away from the Zina and Kosov ordinances, you mentioned honor crimes in Pakistan earlier. What's the legal situation there now regarding acts committed in the name of honor?
This is a very important and positive development in Pakistan's law that you should definitely note. Pakistan's law now expressly criminalizes honor crimes. This is a crucial point.
It's explicitly illegal now.
Yes. It represents a strong legal stance against these acts, which often involve violence, including murder against family members, usually women, perceived to have brought shame or dishonor upon the family. This contrasts sharply with earlier legal situations in some other countries, or even past interpretations in Pakistan, where custom sometimes mitigated punishment for killings committed in the name of honor.
How does the law criminalize it?
Pakistan amended Article 311 of the Pakistan Penal Code. This amendment introduced a mandatory minimum sentence of 10 years imprisonment if an offense, such as murder or assault, is found to have been committed in the name or on the pretext of honor. There is also compulsory imprisonment prescribed for attempted murder or assault carried out for the sake of honor. So remember, Pakistan's law now specifically criminalizes honor crimes with mandatory minimum sentences under PPC Article 311.
That's a very strong legal measure aimed at combating that specific form of culturally justified violence. Okay, finally for Pakistan, let's address the highly sensitive and often volatile issue of blasphemy.
Yes, blasphemy is, without doubt, a deeply controversial and sensitive topic in Pakistan, carrying significant legal and social consequences. The key provision here is Article 295C of the Pakistan Penal Code 1860.
Article 295C, what does it criminalize?
It criminalizes defiling the sacred name of the Holy Prophet Muhammad, peace be upon him. This can be through words, either spoken or written, through visible representations, or through any imputation, innuendo, or insinuation, whether direct or indirect. The scope is quite broad.
And the punishment?
The statutory text of Article 295C initially provided for a punishment of death or imprisonment for life, plus a fine. It seemed to offer judicial discretion.
Seem to. Is that discretion for life imprisonment still actually available?
Effectively, it is not. The Federal Shariat Court, FSC, of Pakistan, which has the constitutional mandate to examine Pakistani laws to ensure they comply with Islamic principles, reviewed Article 295C. The FSC held that despite the statutory wording death or life imprisonment, the only punishment compatible with Islamic injunctions for blasphemy under Article 295C is death.
So the court removed the life imprisonment option?
Yes. This interpretation by the Federal Shariat Court has effectively removed the trial judge's discretion in sentencing and has mandated the death penalty upon conviction for this specific offense. This FSC ruling is crucial to understanding the current legal position.
Have there been convictions under this law leading to the death sentence?
Yes. Tragically, there have been numerous cases brought under the blasphemy laws in Pakistan over the years, and convictions have been obtained, including some leading to the imposition of the death sentence by trial courts. However, often the specific nature of the alleged blasphemy itself is not reported publicly in the media, presumably to avoid repeating or disseminating the material considered offensive.
Which communities in Pakistan are particularly affected or vulnerable under these laws?
The blasphemy laws have disproportionately affected religious minorities in Pakistan. Members of the Christian community and also the Ahmadiyya community have been particularly vulnerable and have faced numerous accusations, prosecutions, and sometimes extrajudicial violence related to blasphemy allegations.
The Ahmadiyyas?
Yes, the Ahmadiyyas are a minority religious group who consider themselves Muslims, but they are not legally recognized as such in Pakistan following a constitutional amendment made in the 1970s. It is also a separate criminal offense in Pakistan for non-Muslims, which includes Ahmadiyyas under Pakistani law, to refer to themselves as Muslims or to propagate their faith in ways deemed to be posing as Muslims. This legal status makes the Ahmadiyya community particularly vulnerable to various forms of legal and social discrimination, including blasphemy accusations.
And there was a very prominent Supreme Court ruling regarding blasphemy relatively recently, wasn't there? The case of Asia Bibi.
Yes, the Asia Bibi case, with the final Supreme Court judgment delivered in 2018, is a landmark decision that you absolutely should remember. Asia Bibi was a Christian woman from Punjab who was accused of blasphemy and sentenced to death by lower courts. Her case attracted massive international attention and condemnation.
And what did the Supreme Court decide?
In a watershed ruling, the Pakistan Supreme Court acquitted Asia Bibi, reversing the lower court decisions. In doing so, the court delivered a very significant judgment that strongly emphasized a fundamental principle of criminal justice: that while blasphemy is undoubtedly considered a very serious offense under the law, like any other criminal charge, it must always be proved by the prosecution beyond reasonable doubt.
Proof beyond reasonable doubt, even for blasphemy.
Exactly. The ruling reinforced the requirement for stringent proof standards, criticized inconsistencies in the evidence presented against Asia Bibi, and highlighted a potential for misapplication of the law, sometimes due to personal vendettas or mob pressure. The Asia Bibi case and the Supreme Court's insistence on proof beyond reasonable doubt is a critical point to remember when discussing Pakistan's blasphemy laws.
That case certainly brought critical legal scrutiny to the application of the blasphemy law and powerfully reaffirmed the importance of fundamental legal principles, even in the most sensitive of cases.
Absolutely. So, as you can see, Pakistan offers a really complex and evolving picture when it comes to applying Islamic penal law concepts. You have the deliberate introduction in 1979, the subsequent realization of severe practical injustices, like the Zina Ordinance's impact on women, the significant legislative reforms in response, like the 2006 Protection of Women Act, while still navigating the ongoing application and interpretation of highly controversial laws like blasphemy under strict interpretations mandated by courts like the FSC. It's a dynamic and challenging legal landscape.
A deeply complex landscape, absolutely, illustrating the challenges, the changes, and the ongoing debates involved in applying classical religious law within the framework of a modern state. Let's briefly turn now to another country that has more recently made significant moves towards implementing a comprehensive system of traditional Islamic penal law: Brunei Darussalam.
Yes, Brunei provides another interesting, though different case study. Brunei Darussalam took a very significant step by promulgating the Sharia Penal Code Order in October 2013. This order began to be phased into full effect over subsequent years.
And this was based on their constitution.
Yes, it was enacted pursuant to specific articles in Brunei's constitution and represented a clear move by the state to fully legalize the application of Islamic penal law concepts specifically, including hudud, qisas, and tazir punishments within the country's formal legal system.
How is this Brunei Sharia penal code structured? Where do we find the offenses?
Part 4 of the code is the main section where the applicable offenses and their prescribed punishments are listed. It's divided into chapters. Chapter 1 specifically outlines the had offenses. Article 55 within that chapter provides a definition of had as punishment ordained by the Quran or Sunnah, and it lists the specific offenses covered: sarika theft, hiraba, robberies, brigandage, zina, illicit sexual relations, qazaf, false accusation of zina, drinking intoxicants, and irtidat, apostasy.
So it lists the classical had offenses. What about qisas?
Chapter 2 of Part 4 covers the qisas offenses and their related punishments. It lists specific crimes falling under this category, providing examples like, interestingly, quathal murder by black magic, which is listed in Article 151 as an offense potentially subject to qisas.
Murder by black magic. Interesting. And are there other types of offenses included beyond the traditional had and qisas categories?
Yes, there's a broader Chapter 4 within Part 4, which is simply titled Offenses. This chapter seems to cover a wide range of other crimes, including those punishable by tazir, discretionary punishment, as well as potentially other acts that the state has chosen to criminalize, some of which might not have been traditionally subject to state criminal penalties in classical jurisprudence in quite the same way.
Can you give an example of something from that offenses chapter that might be considered unusual or controversial?
Yes, a very notable example from this chapter, and one that generated considerable international commentary and internal debate when the code is introduced, is the offense found in Article 194, failure to perform Friday prayer.
Failure to perform the Friday congregational prayer is listed as a punishable criminal offense in this Brunei Code.
Yes, it is. Article 194 explicitly states that any male person who is mukallaf, that's the standard Islamic legal term, meaning mature, sane, and therefore responsible under religious law, who fails to perform the obligatory Friday prayer in a mosque without having a user syari, A valid excuse recognized under Sharia, like being ill or traveling, or some other reasonable excuse, is guilty of an offense under the code.
And what is the prescribed penalty for this failure to pray?
The code lays out a system of progressive fines upon conviction for this specific offense. The penalty is set at $200 for a first offense, $300 for a second offense, and $1,000 for a third, or any subsequent offense of failing to attend Friday prayers without a valid excuse.
Now, why is this particular provision criminalizing the failure to pray considered controversial, perhaps even from within the perspective of Islamic legal history or theory?
This provision is controversial primarily because it directly criminalizes an act that is traditionally classified within Islamic jurisprudence as ibadah, meaning an act of worship. This crosses a fundamental jurisprudential distinction often drawn in classical Islamic law between ibadah, acts of worship like prayer, fasting, pilgrimage, which were primarily seen as matters between the individual and God, and muamalat, social relations, transactions, contracts, and significantly criminal acts against other individuals or society.
So, acts of worship versus social dealings.
Exactly. Traditionally, acts of worship, ibadat, were largely seen as matters of personal conscience and belief. Their validity depended fundamentally on sincere intention, niyyah, and voluntary performance. The reward for performing them, or the punishment for neglecting them, was considered to be primarily from God, especially in the afterlife. They were not typically seen as the domain of the state to enforce through criminal sanctions and punishments in this world.
So, the state stepping in to legislate criminal penalties for a purely religion obligation like prayer is viewed by some as a departure from classical legal theory.
Precisely. If you look at classical juristic texts, they are generally very sparse on the idea of the state imposing worldly criminal penalties for neglecting purely personal acts of worship, like prayer or fasting. While some classical jurists might have allowed the ruling authority some tazir powers to perhaps admonish or publicly rebuke someone who persistently and flagrantly neglected their basic religious duties, making it a formal, punishable criminal offense with codified fines, as seen in the Brunei Code, is considered a contentious matter by many. It arguably blurs the lines between the state's role in enforcing social order and contracts, muamalat, and the state attempting to enforce individual religious piety and obligations, ibadat, in a way not commonly found or endorsed in classical jurisprudence. So definitely remember this point about the potential controversy around criminalizing acts of worship, the ibadat versus muamalat distinction, using the Friday prayer offense in Brunei, Article 194, as a specific example of this modern legal development and the debate it generates.
That's a very clear illustration of how modern codification of religious law can raise new questions and debates, even within the framework of applying classical principles. Are there any other notable aspects in the Brunei Code worth mentioning briefly?
Yes, just to mention one other provision that reflects the specific context of Brunei. Article 209 of the Code makes it an offense to propagate any religion other than Islam to Muslims in the country. This reflects the state's specific policy regarding religious expression and proselytization by non-Muslims within Brunei.
Okay, so Brunei's Sharia Penal Code shows a clear commitment to implementing classical penal concepts like had and qisas, but it also includes provisions like the one on Friday prayers or propagating other religions that generate specific debate and reflect the particular choices made by that state in its modern codification.
Precisely. It provides another important, distinct example of how different Muslim-majority states interpret, codify, and apply Islamic legal principles in the contemporary world, often leading to quite different outcomes in legal landscapes compared to, say, Pakistan or Malaysia or Saudi Arabia.
We have certainly covered a significant amount of ground in this deep dive today. We started by defining those core categories that structure Islamic penal law had: fixed punishments, seen as the right of God; tazir, discretionary punishments decided by the judge; and qisas, retaliation or compensation for homicide injury, seen as the right of the individual with victim control.
Then we delved into the specific had offenses, remember, apostasy, zina, theft, qazr, drinking, hiraba. We emphasized their fixed, often severe punishments, but crucially, we highlighted again and again those extremely high evidential requirements, particularly for zina, 4 witnesses to the act, and sarika, 2 witnesses, no circumstantial evidence for had, which theoretically made applying those severe had penalties very difficult under classical standards.
Then we examined the qisas offenses. We saw how Islamic law represented a major reform of the brutal pre-Islamic blood feuds by introducing key principles like individual liability, the importance of intent, and the necessity of a formal judicial process. Yet it uniquely preserved the victims or their heirs significant control over the final outcome, offering those critical options of retaliation, kisas, compensation daya, or complete pardon remission.
Right. And the McLaughlin and Perry case from Saudi Arabia provided a vivid, real-world example illustrating these Kisa's principles in action, especially the Daya option, and also brought up the important debate around the validity of confessions obtained under duress according to Sharia principles.
And then we spent considerable time focusing on the application of these concepts in modern states, with a detailed look at Pakistan's quite dramatic journey. We trace the introduction of the Hudud ordinances in 1979, the severe and often unintended injustices they caused, particularly the devastating impact of the original Zina ordinance on women trying to report rape.
And then we analyzed the crucial reforms introduced by the 2006 Protection of Women Act. We saw how it moved offenses like rape back to the Pakistan Penal Code, how it redefined and relocated adultery, keeping it under the Zina ordinance but removing tazir, and fornication, making it a lesser PPC offense, how it introduced new procedural safeguards like pre-summoning witness examination, how it tried to address the false accusation issue, Kazroff, and how Pakistan's law now includes significant legal measures against honor crimes.
While also exploring the complexities and controversies surrounding the blasphemy law, Article 295C, the federal Sharia court's ruling mandating the death penalty, and the landmark Asia Bibi Supreme Court judgment powerfully emphasizing the need for proof beyond reasonable doubt in all criminal cases, including blasphemy.
Exactly. And finally, we briefly touched upon Brunei's Sharia Penal Code, highlighting its formal codification of hudud, kisas, and tazir, but also discussing controversial aspects like the criminalization of the failure to perform Friday prayer, illustrating how modern state implementation can sometimes interpret classical principles in ways that generate fresh internal juristic debate, particularly regarding that classical distinction between acts of worship, ibadat, and legal or social obligations, muamalat.
It's clear that understanding these laws requires acknowledging their really complex origins. You've got this blend of scriptural sources, Quran and Sunnah, centuries of diverse and sometimes conflicting juristic interpretation by different schools of law, the undeniable historical influence of pre-Islamic tribal customs, and then overlaid on all of that are the contemporary realities of statutory reforms, political choices, and judicial interpretations made by modern nation-states.
Absolutely. And as we've seen, there is often a significant divergence between the theoretical strictness and the safeguards emphasized in classical legal texts and the varying, sometimes problematic practices seen in the actual application of these laws by different modern states.
It's a deeply nuanced and incredibly important area of law, with profound practical consequences for the lives of individuals in the countries where these laws are applied or debated.
Without a doubt.
So as we wrap up this deep dive, maybe here is something for you, our listeners, especially the students tuning in, to ponder as you continue your studies. How should modern nation-states, particularly those with Muslim majorities, navigate the inherent tension between, on the one hand, seeking to uphold or implement traditional religious law derived from ancient texts and historical interpretations, and on the other hand, meeting the evolving demands and norms of contemporary society? This includes navigating international human rights standards, principles of due process, the role of individual conscience versus state enforcement, especially when, as we've seen, interpretations often differed even within the classical tradition itself.
That is certainly a central question, a challenge that remains at the forefront of legal, political, and social discussions in many parts of the world today. Thank you all for joining us on this deep dive into the complex world of Islamic penal law. We sincerely hope it has provided you with valuable insight and helped solidify your understanding of these key concepts, distinctions, and case examples for your studies.
Yes, definitely take the time to review the key terms we've discussed: had, tazir, kisas, dia, zina, sarika, qad, sarida, hiraba. Really focus on the distinctions between those main categories. Remember the specific, high evidential requirements for had punishments. Know the 3 options available in kisas cases, and be familiar with the details of the legal situation and reforms in key countries like Pakistan, Hudud Ordinances, 1979 Zina Ordinance problems, 2006 Protection of Women Act reforms, blasphemy, honor crimes, and the notable aspects of the Brunei Code. Repeating these key facts will really help. Good luck with your revision and your upcoming exams from all of us here and from Sinorbit Academy, Sri Lanka.